Before you roll your 401k into an IRA, there is one major protection issue you need to understand. Many retirees are told that moving money from an old 401k into an IRA is the obvious next step. It can give you more investment choices, easier management, and possibly lower fees. But there is a legal trap hidden inside that decision. When you move the money, some creditor and lawsuit protections may change. A 401k is not just a retirement investment account. In many cases, it is protected by a federal law called ERISA, which governs employer-sponsored retirement plans. That protection is powerful because it is federal, consistent across states, and generally has no dollar limit. Whether your 401k has $20,000 or $2 million, a creditor with a large claim usually cannot reach it. There are some exceptions. The IRS may be able to access it. A divorce court may divide it through a qualified domestic relations order. Criminal restitution may also reach it in certain cases. But for many ordinary civil lawsuits, the money inside a 401k is usually protected. This matters because lawsuits can happen in many ways. A neighbor could fall on your property and sue you. A business deal could fail and lead to a claim. A parking lot argument could turn into a serious injury lawsuit. While the money remains inside a protected 401k, creditors generally cannot get to it. The 401k sits outside the fight. The same protection also applies in bankruptcy. Lawsuits and bankruptcy are different legal situations, but a 401k generally has strong protection in both. That is why moving the money into an IRA deserves careful thought. Once you roll a 401k into an IRA, the protection may shift from federal law to state law. That is where things become less predictable. Some states protect IRAs very strongly. Some protect them only up to a dollar amount. Others use a reasonably necessary standard, meaning a judge decides how much of the IRA you actually need to live on. In a needs-based state, the court may look at your age, health, social security, pension income, rental income, other assets, and living expenses. If the judge decides you do not need the full IRA balance for support, the extra amount may be available to creditors. That is very different from a 401k, where the answer is often a much clearer no to creditors. For example, a 75-year-old with no other income may have more of an IRA protected than a 60-year-old who is still working part-time and has other sources of money. The same IRA balance can receive different treatment depending on the person's situation. In states like California, courts have allowed creditors to reach large amounts inside IRAs, so this is not just a theoretical concern. There is also another wrinkle. Roth IRAs may not always receive the same protection as traditional IRAs. Some states offer less protection or even no protection for Roth IRAs compared with regular IRAs. According to the source mentioned in the original video, states such as Alabama, California, Georgia, Maine, Mississippi, Nebraska, and West Virginia may treat Roth IRA protection differently. So if you are planning a Roth conversion, you should consider creditor protection along with taxes. Not every state is risky though. Some states have dollar caps. Nevada is used as an example. Its old IRA protection cap was $500,000, but under newer rules, the cap is $1 million. That means many retirees may be fully protected if their IRA balance is under that level. But if someone has $1.4 million in an IRA and the state protects only $1 million, the remaining $400,000 could be exposed. The lesson is not that IRAs are always bad. The lesson is that you must know your state's rules. Your state may offer full protection, capped protection, or needs-based protection. Each situation creates a different risk. Bankruptcy has a special rule for rollover IRAs. If you roll 401k money into a dedicated rollover IRA, those funds may keep unlimited bankruptcy protection, but there are important conditions. The account should contain only rollover money from the 401k, and you should not add new IRA contributions to it. Investment growth is fine. Buying and selling investments inside the account is fine, but adding new money can create a tracing problem. For example, if you have $3 million in a rollover IRA and later add an $8,000 IRA contribution, the account is no longer purely rollover money. A bankruptcy court may have difficulty separating the original rollover funds from the new contribution and its growth. This can put the stronger bankruptcy protection at risk. A regular contributory IRA is still protected in bankruptcy, but only up to a federal limit. For 2025 through 2028, the limit mentioned in the original video is $1,711,975. Rollover dollars do not count against that cap if they remain properly separated. but if the account becomes mixed, a large portion could potentially become exposed. Also, this rollover bankruptcy protection applies to bankruptcy, not ordinary lawsuits. On the stronger end, some states offer broad IRA protection that looks more like 401k protection. The original video mentions Florida, Texas, Washington, Illinois, Connecticut, Indiana, Iowa, Kansas, New Jersey, New Mexico, Oklahoma, and Oregon as examples of states with strong protection. Florida is highlighted because its law protects IRAs, Roth IRAs, SEP IRAs, simple IRAs, rollover IRAs, and even inherited IRAs without a dollar cap. Inherited IRAs are another major issue. In many states, once your children inherit your IRA, the account may lose protection from their creditors. If a child faces divorce, bankruptcy, or a lawsuit, the inherited IRA could be vulnerable. Florida is one of the states that may protect inherited IRAs more strongly. If leaving retirement assets to children is part of your plan, you should ask an attorney about whether a properly drafted trust would provide better protection. If you are thinking about moving to another state, creditor protection should be part of your retirement checklist, along with income taxes, property taxes, healthcare, and lifestyle. For bankruptcy, there is also a 730-day rule. Generally, the state exemptions you can claim depend on where you lived during the 2 years before filing bankruptcy. You cannot simply move to a more protective state shortly before filing and expect to use that state's bankruptcy protections immediately. Another practical layer of protection is umbrella insurance. An umbrella policy provides extra liability coverage above your homeowners and auto insurance. If someone sues you and your base policy reaches its limit, the umbrella policy may cover the remaining amount. This can be especially useful for personal liability claims, such as someone falling on your property. Umbrella insurance is often relatively affordable compared with the amount of protection it provides. However, it does not cover everything. A business lawsuit may not be covered. An intentional physical altercation may not be covered. A slip and fall claim at your home is more likely to fall within coverage, depending on the policy. The action steps are clear. First, find out how your state protects IRAs. Check traditional IRAs, Roth IRAs, rollover IRAs, and inherited IRAs separately. Second, review your umbrella insurance coverage. Third, be cautious about rolling a 401k into an IRA if you live in a needs-based state. Fourth, if you do roll over, consider using a dedicated rollover IRA and do not contribute new money to that account. Fifth, if you plan to leave money to your children, speak with an attorney about trust planning. Finally, if you plan to relocate, include creditor protection in your decision. Rolling over a 401k may still be the right move for some retirees, but it should never be automatic. Before moving the money, understand what legal protection you have now, what protection you may lose, and what rules apply in your state.